The lien was already filed, signed in my name, notarized, filed against my house. A $6,200 claim I had never authorized. I found out on a Tuesday morning, not from the HOA, not from a lawyer, from my mortgage servicer, calling to ask if I had authorized a lien against my property. I hadn't. She read me the document number, lien reference LN 4471, filed with the county recorder's office 17 days earlier, signed, according to the filing, by me. I told her I hadn't signed anything. She read me the signature line again, my name, my address, notarized. I set the coffee down. I asked her to email me the document. Then I sat at the kitchen table and read it twice, slowly, the way I read things when I need to be sure I'm not missing something. I wasn't missing anything. That was the problem. That's when it stopped being an HOA dispute. This was fraud, and not the kind you argue about in a meeting. They thought they were dealing with a homeowner who didn't understand the system. They assumed I'd do what most people do, pay it, move on. That assumption turned out to be expensive. But this didn't start with the lien. It never starts there. It starts small, the way these things always do, with something so minor you wave it off because you're busy, and it looks like a mistake, and you genuinely believe that reasonable people, when corrected, behave reasonably. That belief cost me 8 months. I bought the house in 2009. My wife Carol passed in 2017, pancreatic cancer, 11 weeks from diagnosis to the end. After that, the house wasn't just a place to live, it was something I held on to. The HOA had been background noise the entire time I'd lived there. Ridgecrest Community Association, annual dues of $1,140, a board that concerned itself with the entrance gate and the pond, and not much else. I paid my dues every January, attended no meetings, caused no issues. That changed in the spring of 2022. A man named Dennis Crail ran for board president and won by 4 votes. Semi-retired commercial property developer, the kind of man who walked into rooms already knowing how they were going to end. He sent an introductory letter within 2 weeks of the election. Warm tone, promises of consistent enforcement, improved communication. A phrase near the bottom that I read once and didn't think about again. Ensuring that all community assets and common interests are properly protected. I thought it was boilerplate. It wasn't. The first violation notice arrived in August of 2022, VN 0118, my converted garage, cited under CC&R Section 5.1.1, operating a commercial enterprise from a residential property. Fine, $275. I work in a field where documentation matters. Reading the actual language of a rule before responding, that's second nature. Section 5.1.1 defined commercial use as regular business transactions involving external clients or customers conducted from or at the residential property. I had no clients visiting, no customers, no external transactions at the property. I worked from home occasionally, desk work, reading, writing, same as half the neighborhood since 2020. The citation didn't fit the rule, not even close. I called Lake Crest Property Solutions, the management company, spoke to a man named Gary who said he'd note my concern. I followed up with a certified letter explaining the mismatch between the language and my actual activity. Kept a copy. Waited. 9 days later, 1 paragraph back. The board maintains its original position. The fine of $275 remains assessed. No analysis, no response to the language issue I'd raised, Just, we've decided, and that's that. I paid it, not because I agreed, because $275 wasn't worth a fight yet. And I still believed, in August of 2022, that this was a new board finding its footing. Give it time, it would correct itself. That was my first mistake. The second notice came in October. VN0201. Same section, same fine. This time with a new line at the bottom. This represents a second citation. Further violations will result in escalating fines and potential referral for lien placement under Section 14.2 of the CC&Rs. I read that line twice. Lien placement. That weekend, I drove the neighborhood slowly. A man on Birchwood Lane ran a licensed in-home daycare. Visible sign in his front window. Vehicles dropping children off every weekday morning. A man on the North Loop had a landscaping business operating out of his driveway. Magnetic company signs on both trucks. Trailer parked on the street 3 days a week. A home on the east side had a medical aesthetics placard near the front entrance. 3 properties with a far stronger claim to Section 5.1.1 violations than anything happening at my house. No notices on any of their doors. I went home and started writing things down. Dates, addresses, observations, photo file names with GPS tags. In my line of work, the written record is everything. What you can prove matters more than what you know. I approached this the same way I approached everything else that required precision, methodically, without rushing. That's when it stopped being a mistake in my mind. Mistakes don't enforce selectively. Mistakes don't read the CC&Rs and then apply them only where convenient. What was happening at my property was being decided, not blundered into. I filed a formal appeal of both violations in November, cited the actual language of Section 5.1.1. Attached dated photographs of 3 neighboring properties with documented commercial activity. Requested a hearing before the board. Certified mail, return receipt, copy retained. 12 days passed with no response. Then Gary from Lakecrest called to tell me the board had scheduled a hearing for February 14th. I wrote it down, went back to work. The February hearing was a Wednesday evening in the Ridgecrest community room. Fluorescent lights, folding chairs, the particular atmosphere of institutional spaces used only for unpleasant purposes. Crail sat at the center of the board table. Janet Moores to his left, Phil Sotheby to his right. My neighbor, Patrice Lien, sat in the back row. She'd told me in December that others had been receiving unusual notices. She came to watch how Crail ran things. I presented for 18 minutes. I kept it clean. The CC&R language, the absence of any activity meeting that definition at my property, the documented non-enforcement at 3 specific addresses. I didn't raise my voice. I didn't speculate about motives. I laid out what the record showed and let it sit there. Crail listened with the patience of someone who had already written the ending. He said the board applied its standards consistently. Individual circumstances varied. The board exercised discretion in CC&R interpretation and had done so appropriately. I asked directly whether the 3 properties I documented had received violation notices. He said the board had nothing further to add. Phil Sotheby looked at the table during that exchange. Janet Moores looked at Crail. The vote was 2-1 to uphold the fines. Sotheby voted to reverse. He didn't explain himself. He just voted no, and then looked at his hands. I drove home thinking about Crail's face during my selective enforcement question. Not defensive, not flustered, settled. He'd known the question was coming, prepared his non-answer in advance, and delivered it with the ease of a man who didn't expect consequences. He wasn't running a sloppy enforcement regime. He was running a deliberate one. I filed a formal complaint with the state HOA regulatory office in March. Selective enforcement, procedural violations, failure to provide a written ruling within the CC&R's own specified time frame. Case ID SE 2023-0847. Confirmation letter arrived. Investigation timeline 4 to 6 weeks. 6 weeks went and came. I called the office. Phone tree. 8 minutes of navigation. Voicemail. Left a message. No callback. Called again 3 days later. Different voicemail. Another message. On the 12th day, a woman named Barbara called back. She told me the case had been assigned to an investigator, and I'd be contacted in due course. I asked for the investigator's name. She said she couldn't provide that. I asked for a status update beyond active. She said the case was active. That was the entire conversation. If you've ever dealt with a regulatory office, you already know how that goes. You file the right paperwork, use the right language, and then you wait while a process designed to help you moves at whatever pace it decides. I kept documenting. The regulatory complaint was one track, the paper record was another. I learned a long time ago that you don't stop building just because one path is moving slowly. In May, VN 0441 arrived. $800. This time, Crail invoked Section 14.2 directly, not as a future possibility, as an active warning. Failure to satisfy outstanding violations totaling $1,050 within 60 days will result in initiation of lien proceedings. That's when things got expensive. Not just financially, in terms of what was actually at stake. $1,050 was the 3 fines combined, all still under active dispute. The CC&R's own language required that fines under appeal could not be referred for lien action until internal processes were exhausted. That process was not exhausted. The regulatory complaint was still open, the February hearing outcome still under challenge. They knew that. They sent it anyway. I contacted a colleague I trusted, a former clerk named Sasha Orimoto, gone into private civil litigation, specifically property and HOA law. She'd worked closely with me for 2 years before going out on her own, thorough in the way quiet people often are. I explained everything. She listened without interrupting. When I finished, she said, "How documented are you?" I told her. She said, "Good, don't stop." Then, if they file a lien without completing the dispute process, that's not just a CC&R violation, that's actionable misconduct. She drafted a cease and desist within 48 hours. It cited the open regulatory complaint, the pending challenge to VN 0441, and the specific CC&R language prohibiting lien referral during active dispute. She sent it to Crail, to Lakecrest, to each board member individually. Certified mail. Return receipts came back signed. Crail signed for his copy on a Thursday. 63 days later, my mortgage servicer called. I stood in the kitchen, coffee too hot to drink. LN 4471. Filed 17 days earlier. signed, allegedly, by me. I called Sasha before I'd moved from the spot where I was standing. She pulled the filing from the county recorder's database while I was on the phone. It's a public record, accessible to anyone. She was quiet for almost 30 seconds. Then she said, "The notary seal on this document is registered to a Carolyn Bass. She's listed as an employee of Lakecrest Property Solutions." I wrote the name down. She said, "Does the HOA have any document with your actual signature on file?" I thought about it. The original CC&R purchase acknowledgement, signed at closing in 2009, standard document required for all buyers, 14 years old. Sasha said, "That's what they used." She said it the way you say something when the shape of a thing becomes suddenly completely clear. They had taken my signature from a 14-year-old onboarding document, transferred it to a lien authorization, had an employee of their own management company stamp it as notary without witnessing my signature, and filed it against my property title. Under state law, that wasn't a CC&R interpretation question. It wasn't the kind of thing that gets resolved at a board meeting. That was forgery. That was notary fraud. Those were crimes, with specific statutes, specific penalties, and a paper trail that led directly back to the people who made the decision. He'd wanted leverage. What he'd created instead was a record. And here is the part Dennis Crail had not checked. What the HOA didn't know, what nobody on that board had thought to verify before forging my name on a legal instrument and filing it with the county, was what I did for a living. He had filed a forged legal document in a system I knew very well, a system I worked inside every day, because for the past 11 years I'd been a county circuit court judge, and he had just committed a felony in a jurisdiction I understood better than he ever would. I knew exactly what a fraudulently notarized instrument meant under state law. I knew which statute it fell under, which agency handled criminal referrals, who ran the relevant division of the state attorney general's office, because I had referred cases to that office before. I knew the exposure. I knew the process. I knew, sitting at that kitchen table with cold coffee and a forged lien in front of me, precisely what was available to me and precisely how to use it. Not because I was going to abuse my position. The job comes with obligations that run in both directions. I take them seriously. But I knew the system. I knew how to document, how to file, how to build a record that holds. And I knew that what Crail had done had just left the administrative world where he'd been comfortable operating and moved somewhere else entirely. I finished the cold coffee. I called Sasha back. I told her to start preparing the criminal referral. She said, "Already started." Then she said something that made me stop. She said, "I pulled the court calendar this morning. Crail has a hearing scheduled for next Thursday, commercial property dispute, one of his development companies." I pulled up the calendar myself. Dennis Crail was scheduled to appear in my courtroom. He didn't know I was the presiding judge. Nothing in the case file would have indicated it. He would have seen a case number, a hearing date, a time. He wouldn't have seen my name until he walked through the door. Sasha said carefully, "You recuse the moment the session opens. State the reason on the record. Clean and by the book." I said, "That's exactly what I'm going to do."
I went through the rest of the week the way I go through every week. The docket doesn't stop because your personal life is complicated. 4 hearings Wednesday. Brief review Thursday morning before the Crail matter was called. He was already at the plaintiff's table when I entered. Gray suit, leather portfolio, talking to his attorney with the ease of a man who'd been in rooms like this before and believed he understood how they worked. He didn't look up when I entered. The clerk called the case, and then Crail looked up. And he saw me. He recognized me, and he knew exactly what that meant. It wasn't panic on his face. It was something more specific than that. Recognition. The kind that moves across a person slowly when they understand that the rules they'd been playing by don't apply in this room. That was the first moment he understood where this was going. I stated for the record that I had a material conflict with the plaintiff in this matter and was recusing immediately. I asked the clerk to arrange reassignment. I thanked both parties for their time, and I left the bench. I was in my chambers for 4 minutes. When I came out into the hallway, Crail was standing near the far wall. His attorney was speaking to him in a low, quick voice. Crail wasn't listening. He was looking into the middle distance with the expression of a man recalculating something he thought he'd already solved and realizing he hadn't. I walked past without stopping. I had a 1 o'clock on a different matter. Sasha filed the civil complaint the following Monday. Fraud, document forgery, abuse of HOA authority, violation of the state statute's conflict of interest provisions. The same day, she filed a formal criminal referral with the State Attorney General's Office, White Collar Division. Attached, the lien document, my original 2009 CC&R signature page, a forensic document comparison prepared by an examiner Sasha had worked with previously, and the notary registration records of Carolyn Bass of Lakecrest Property Solutions. The AG's office opened an investigation in 9 days. That's faster than these things usually move. There was context to that speed. Document fraud involving property liens had become a specific enforcement priority that year. There had been other cases, other HOAs, other management companies, similar methods. Mine wasn't an isolated incident. It was part of a pattern investigators had already been building toward. He wasn't improvising. He was following a playbook. He just hadn't considered what happens when you use it on the wrong person.
Phil Sotheby reached out to Sasha 3 weeks into the investigation. He had emails, not just board minutes, internal communications. One from Crail to Janet Moores, dated 2 weeks before LN 4471 was filed, discussing the authorization process in terms that made no reference to obtaining my actual consent. Another describing lien authority as the most direct mechanism to create incentive for compliance. Sotheby had been sitting on those emails for months. He said the word directly when he spoke to Sasha. Ashamed. He'd known something was wrong, he hadn't acted, and it had gone farther than he'd believed it would go. He gave everything to the investigators without being asked twice. Carolyn Bass, the notary, cooperated within days of the AG's office making contact. She provided a sworn statement confirming she had stamped the lien document at Crail's instruction without witnessing my signature. She said she'd been uncomfortable, but hadn't known how to refuse. Her notary commission was suspended the same week. Carol Moores resigned from the board without a statement. Her name simply stopped appearing on correspondence. Crail hired a criminal defense attorney. His civil attorney withdrew shortly after. The civil case settled in October of 2023. The terms: all 5 violation notices voided in their entirety. LN 4471 formally released from my property record, with the release filed by the HOA's own attorney at the county recorder's office. $11,340 in documented legal fees and costs paid within 30 days. A written retraction issued to every Ridgecrest homeowner acknowledging that the enforcement actions against my property had been improper. And a full independent audit of every lien and fine issued during Crail's presidency. The audit found 2 other homeowners who had been improperly fined. Both received full restitution from the HOA's reserve account. The criminal matter moved the way criminal matters move, slowly, procedurally, without the drama people imagine. Crail entered a plea to 1 count of filing a fraudulent instrument with a public office and 1 count of conspiracy to commit notary fraud. 18 months of supervised probation, a $15,000 fine, and a permanent ban from serving as an officer of any homeowners association or property owners association in the state, which, considering how this started, felt appropriate. It also felt final. The lien release was recorded on a Friday in November. I drove to the county recorder's office and picked up the certified copy myself. The clerk stamped it, slid it across the counter, and asked if I needed anything else. I said no. I folded it in thirds and put it in my jacket pocket. I drove home the long way, past the Ridgecrest entrance, past the community pond, past Birchwood Lane. The daycare on the corner still had its sign in the window. A minivan pulling away from the curb. Ordinary afternoon. Patrice knocked on my door 2 days after the settlement retraction went out to all homeowners. She stood on my porch with her hands in her coat pockets and said, "I'm glad you didn't just pay them and let it go." I told her it had been a close thing for a while. She said she doubted that. She was being kind. The new board was elected in January. Rosa Sotheby, Phil's wife, which surprised me slightly, ran on procedural transparency and won by a margin that wasn't close. First thing, post the full CC&Rs online with plain English summaries of each section. Second, a mandatory conflict of interest disclosure policy requiring annual filings from all board members. I read both documents when they came through. Thorough. The kind of structure that makes certain problems harder to hide and certain people less likely to try. The following winter was quiet. The wood stove in the garage ran clean and warm through February. No violation notices, no certified letters with return receipt cards. Some mornings I'd take coffee out to the back porch and listen to the creek before heading to the courthouse. Same as always. The light on the water, the same as it had been the morning Carol walked through the house and made her list. I still haven't renovated the kitchen. In March, I moved the folder, violation notices, lien documents, certified mail receipts, settlement agreement, from my desk drawer to the filing cabinet. In May, I moved the cabinet to the back of the garage. I haven't opened it since. One morning in April, I walked out to the mailbox in the early light and stood there a moment longer than necessary. Nothing moving on the street. Creek audible from where I stood, just barely, over the sound of birds. Water bill, a seed catalog, a postcard from a colleague traveling somewhere warm. No more notices, no more letters. Funny how that works. I went inside and started the coffee.